Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. I am going to also come with a great topic for you today. I'm going to be talking about applying for your spouse's permanent residence, excuse me, even in the case where they have a past immigration violation or they have a criminal offense in their past. Is it possible? Absolutely, it is still possible to apply for your spouse to get permanent residence. But remember, it's going to come down to your particular circumstances, your spouse's particular circumstances, and the facts involved. But the important takeaway here is that it is absolutely possible to bring a spouse who has maybe been deported previously, maybe gone through expedited removal previously, maybe they've overstayed previously, maybe they have gone back, but in the past they had unlawful presence, and even in the case where they have criminal offenses on their record. So I'm going to go through how you can go ahead and apply despite these past violations. Now, let me remind you that as I'm introducing the topic today, you can type your questions in the comments and I will answer as soon as I'm finished discussing the topic. And that's going to be just in a few minutes. So put your questions in the comments so you can get a head start on those questions while I'm here. Now, if your spouse has previously been deported, if they have overstayed, if they've crossed the border without permission, if your spouse has had any criminal issues, there are waivers available. And what I mean by waivers is waivers are a type of way to apply for forgiveness for those violations in the past. Now, whether or not you qualify for the waiver is going to depend on the facts involved, and it's going to depend on whether you fall within a category to qualify for the waiver. That's where it's very important to schedule a consultation. Hi there, Lady Ching. Thanks so much for the love. I appreciate it. Thanks for your time as well. Now, when your spouse, now this waiver, it's going to depend on the type of violation, but I'm going to go through some of the most common violations and the types of waivers that are available. So let's start with the criminal. If your spouse has a past violation in the past and it has rendered them inadmissible, they could always apply for a waiver based on so it's called a 212H waiver. And in this case, there are two ways that this could go. The one is if it has been more than 15 years since the offense occurred, then they don't necessarily need a qualifying relative to qualify. They just need to show that they've been rehabilitated and that it's not going to be against public interest to admit you again. And by the way, these are waivers for permanent residents where you're coming back to live permanently. If it's been less than 15 years since a criminal offense, then you would need to have a U.S. citizen or legal permanent resident spouse, a parent, or a U.S. citizen son or daughter. And in this case, you would have to prove that your son, your daughter, your spouse, your parent will experience extreme hardship if you're not granted permanent residence. So there are additional requirements just depending on how much time has passed since the offense. And if it's been less than 15 years and you don't have any of these qualifying relatives, then you may not qualify for the waiver. You will not qualify for the waiver in this case. But if it's been more than 15 years, you don't need these relatives. You just need to show that you have been rehabilitated and that it's not against public interest to let you back in to get permanent residence. Now, There are two types of criminal conduct that's waivable, meaning you can apply for permanent residence. And then there's the very bad one where you can't apply. So it's called aggravated felony, where there's no waiver available. However, and I'm going to list the possibilities here. So say you have been arrested, say you've been convicted for a crime. This could go three different ways, right? It could be a serious crime that it is considered an aggravated felony under immigration law, and there's no admissibility, there's no waiver for that. This could be where you have been convicted of a crime involving moral turpitude. That definitely requires a consultation to determine whether the crime would fall under this category, but it's where the behavior or the offender is so depraved that they commit a crime that's inconceivable. For example, assault can be considered a crime involving moral turpitude. In this case, then we're going to have to evaluate it based on, has it been more than 15 years or has it been less than 15 years? Then there's also, if you have committed, if you've been convicted for crimes, multiple offenses, 2 or more, that have added up to a total of 5 or more years, a 5 or more year sentence. If this is the case, we would also look at the type of crime involved, whether it's waivable or not. Now, the other is drug trafficking. There's no waiver for drug trafficking. So if you've been convicted for a crime involving drug trafficking, you'll have to look at other forms of relief to see maybe if you're in the middle of going through your process, whether this could be, if you could plead down your charges, whether it has to involve drugs or any kind of drug trafficking, whether the drug involved falls under the federal list of controlled substances. That is a more complex analysis and would have to look at it to see whether or not you would even qualify for a waiver. But generally, drug trafficking will mean that you won't get a waiver. And that can be painful for some families. There's also misrepresentation. So if you have been convicted, not charged under immigration law, it's not usually criminally, maybe criminal, but it could just be under immigration law, misrepresentation or fraud. There is a waiver for that if you have a U.S. citizen or legal permanent resident, spouse or parent. And if you've overstayed, then you've accrued unlawful presence, you've been in the U.S. for more than 3 months without legal status, more than 6 months. I apologize for that. It's more than 6 months. If you've been in the U.S. for more than 180 days without legal status, you would accrue unlawful presence. And this makes you inadmissible, ineligible for permanent residence unless you could get a waiver. There are some other exceptions, and that's for another day. But for example, if you're the spouse of a U.S. citizen and you're here in the U.S., then you will not have to deal with the waiver if you're going through adjustment of status. But you have to overstay. If you've crossed the border without permission, you're going to need that waiver. So, and for the unlawful presence, you will have to have a U.S. citizen or legal permanent resident, spouse or parent. Also, if you've been charged with smuggling and you've smuggled in your spouse or your child or children, then there's a waiver for that as well. You do have to show that you smuggled in your wife or your children. Anybody outside of that, if it's a sister, a cousin, a friend, unfortunately, there's no waiver for smuggling. So that is a very serious offense. But if you were doing it for your spouse or your child, then that could result in, that could have different results and you could apply for a waiver. Now, what I want you to take away from all of what I said is you can apply for a waiver. It's possible to get forgiveness, to go on to get your permanent residence. How you're going to do that is going to depend on your particular facts. That's where you should schedule the consultation. My number is they're all over my videos. You can also go to the link in the profile. So Island Goodness, you want to get in touch, go to the link in the profile. You'll see different options. You'll see an option to schedule your own appointment. You will see an option to go ahead and schedule a call. Go to the website, you can call, you can fill out a contact form, or you can do online chat. All of these methods lead to a scheduling coordinator who will be more than happy to assist you to schedule your appointment. Now I'm going to go to questions. So let's see what questions we have here. So I applied for the I-485 in February 2022 for parents inside USA. Do we need to do anything else? Whether or not you need to do anything else is going to depend on your facts. I'm not your attorney. I haven't reviewed your case, and that's going to be very essential here. So I wouldn't be able to advise you about what you need to do because I don't know your case. Received my green card through VAWA based on green card holder. How long can I apply for my N400 application? So in this case, you're married to a green card holder, so it's going to be the 5 years that you must wait. So 5 years to apply for US citizenship. How do I get in contact with you? So I answer that. When should I file to remove the condition from my green card, which expires May 25th, 2023? So you will need to remove those conditions by applying with the I-751 jointly with your spouse. If you and your spouse are no longer together, you'll have to apply for a waiver, and this must be done within the 90 days before your card expires. If you're applying for a waiver, you can apply for it at any time. But you want to make sure that you're applying for it before it expires within 90 days. If you can't apply jointly with your spouse because you're divorced, because they're mistreating you, or because you can't apply with your spouse and you'll experience extreme hardship, then that's where you need to submit that waiver. I can advise you, just go ahead, call, schedule an appointment. We can talk more about it. My daughter sponsored me from last year till now. I did not hear from them. So yes, it is taking a while, and you should just make sure you check on your case. Marriage to a green card, I think this is green card holder. How long should I receive my work authorization? So if you're married to the green card holder and you applied for adjustment of status, it's going to come down to whether or not you qualify in the first place. There are very specific requirements. You do have to maintain your legal status at the time that you applied for the permanent residence through adjustment of status. But you could be seeing anywhere from 3 months to 10 months to get that work permit. Now, keep in mind that the information I'm giving you here is general information. Do not rely on it until you've scheduled a consultation. Because if this is general, I don't know your facts. I haven't evaluated your case in detail. And so you can only take this at face value. If you would like personalized legal advice, that's where you're going to schedule the appointment. So I applied for AOS for parents in February. I-94 expired. What else needs to be done? So I can't advise you in this case because I'm not your attorney. I do answer general questions, but I don't know what else you can do if I don't know your case and I haven't reviewed it. So that's where you need to consult your attorney. I submitted an expedite but haven't gotten a response. So Shauna, if you've submitted the expedite, just make sure you've submitted it properly. Usually it's by phone, and then if they need any further information, they'll get in touch with you. I have seen expedite requests being processed anywhere from 1 week to 3 weeks to get that expedite request processed. Do you think U visa will go through fast or still wait all the time? So right now, the way that they're dealing with the U visas is they're issuing work permits as long as you submit a proper application. So you just, that's one way to get some relief. Unfortunately, yes, there is a backlog, and that backlog is going anywhere from 7 to 10 years. And so it is, that is definitely the nerve-wracking and frustrating part of the process. But last year, they updated the system to allow you, as long as you properly filed an application and you get a bona fide filing determination, they would issue a work permit. You'd have to apply for it, of course, after you get the bona fide determination. My company wanted to file for me. What are the requirements? So the company, if the company wants to file for you, the company is going to have to consult with the attorney. For example, they could always consult with me. In this case, they would have to go through a labor certification, and that includes what's called wage determination process. They just want to make sure that by giving you the position, they're not undercutting qualified US workers. And then after that's approved, you could be looking at 6 months for that. But once it's approved, then the company will have to file the petition if they're going to be the ones petitioning for you. And they would submit that petition to the USCIS to be processed. Depending on where you are and what your status is, you would either apply at the embassy, or if you qualify, as long as you haven't fallen out of status, you could apply here. It is a complex process. Your employer needs to schedule a consultation to get that, to get the proper legal advice and representation to go through the process. Because what I listed here is the simplistic version of a complex process. What do I need to do to file for my brother and sister who are there in high school? So now keep in mind, applying for your siblings isn't going to be fast. It is taking 14 years to apply for your siblings. So get legal advice to ensure that the option you're thinking about is the right option for you. Now, also, if your brother and sister are here and they're without their parents, then there is what's called the SIJ S. So it's a special immigrant juvenile status. And it allows, if they're under 18, what we do is we work to get a predicate order done through the court, and then the court will issue an order and allow the kids who are without their parents due to maybe mistreatment or abandonment to be able to get adjustment of status, get their permanent residence and their work permit through that process. So if that may be a faster process, just depending on the circumstances of the kids and what they've been through, your brother and sister. And it depends on whether they're here. They have to be here in the US. If they're not, then it may be another option. But we need to determine what your situation is first. Can a person get a green card if they have domestic violence records that have been expunged? Now, keep in mind that expungement doesn't get rid of what happened. Under immigration law, you still have to disclose it, and they still have to make a determination. They do take domestic violence very seriously, and this could result in an inadmissibility. So you want to schedule an appointment. Definitely get the legal advice you need to understand what you will need to get permanent resident. It may be possible, but we'd have to look at the facts involved in the domestic violence situation. But that is considered a serious offense under immigration law. Great questions, great relevant questions. I'm both on YouTube. I'm checking the comments. Thanks so much for your question on YouTube. And I'm also monitoring TikTok. So put those questions in the comments and I will answer those questions. That's what I'm here to do. Now, I am U.S. Immigration Attorney Sharifa Tharpe. This is my job, is to help you through a complex process under immigration. So what you can do is schedule an appointment if you need specific legal advice and representation through your process. Can a person still qualify for H-2B program if they are being filed for? So under the H-2B program, they are going to consider whether or not you have immigrant intent and whether you're at risk for overstaying. And so if you've been filed for, that could compromise your ability to get the H-2B. They would have to be convinced that after your program, you will go back even though you're being filed for. Do I have to mail docs to NVC even though I send them on their site? So usually if you upload the documents to the site, they don't usually require them to be sent by mail. However, I'm not your attorney. I haven't reviewed your situation. I'm not managing your case. And so there may be special instructions involved that I have not identified. So you need to make sure you get legal advice, consult with your attorney. I have a visitor visa. A restaurant wants to sponsor me. Please help me here about status change. So this is definitely going to warrant this is going to warrant a consultation. Because if you're here on a visitor's visa, then you have to look at the timeline to be able to get the permanent residence through, or I don't know what, if it's an H-2B, is it an H-1B, is it what type of visa is it? It's going to depend on the type of visa, whether this is permanent residence, and the timeline it's going to take. You may not be able to do change of status. You may have to wait out the process in your country. And the process could take anywhere from 18 months to 2 years, just depending on how long each step takes. So schedule an appointment. In this case, if your employer wants to sponsor you, it's going to be your employer that should be getting the legal advice because they're going to be 100% involved in your process. So you're going to want to make sure you tell your employer that they need to get the right guidance to sponsor you. All right, that's going to be it for me today. Thanks so much for your questions. I'm not done yet though. I'm going over to Instagram and Facebook. I'm ST Law Office on Facebook and I'm the Immigration Attorney, same as here on Instagram. If you have more questions, if I didn't get to your question, go ahead and join me over there where you can continue to ask your questions and also listen to the topic that I have to talk about. So I will see you. Now I am here Mondays through Fridays at 4 p.m. Eastern time. So you can always join me tomorrow or go ahead, schedule your consultation if you have very specific questions, because the information I'm giving is general information. It is not legal advice. So go ahead, make sure you schedule that appointment to get the personalized legal advice so you avoid mistakes and you do everything correctly. So for example, if your employer wants to sponsor you, under no circumstances should you be overstaying, because that would be a big mistake. There's sometimes no way to fix that situation or it gets very complex. So make sure you get the legal advice you need before you do anything. All right, thanks again. I'll see you tomorrow at 4 p.m. Eastern time, or I'll speak with you in a consultation, or I'll see you in a minute on Instagram on The Immigration Attorney. Have a great one, everyone. See you tomorrow.